Are you in the United States after having entered on a tourist visa and now you're married to a US citizen and wondering about how you might go about filing for your green card? I want to talk about that in this video. My name is Ashley. I'm an immigration attorney. I have two office locations, one in Carlsbad, California, the other in Bend, Oregon. However, my office serves clients located all over the United States. So in this video, I want to answer the question of how can I apply for a green card if I'm in the US, I last entered on a tourist visa, and now I'm married to my US citizen spouse. This is a process that's called adjustment of status. So the way that this works is that your US citizen spouse needs to file an I-130 petition for you, which is the petition that tells immigration that your marriage is bona fide, it's legitimate. This petition gets filed at the same time as a lot of other paperwork for your case, which includes the green card application, a work permit application, a travel document application, as well as the affidavit of support application, which is what your US citizen spouse is required to complete along with their financial information to show that they earn enough to support you in the United States so that you will not become a public charge. So the way that this all works is that all of these forms, along with all of the required supporting documents, get filed together and they get sent together to one location at USCIS. Once the case is pending, you, as the immigrant, become eligible to receive a work permit and a travel permit. Now, the work permit is obvious. It's a document that allows you to work legally in the United States while your adjustment of status application is processing. The travel document is very important to understand. Without this document, you are not allowed to depart the country. Otherwise, if you do, you risk abandoning your entire adjustment of status application. So that means that if you leave the United States after you file your adjustment and you are leaving without this travel permit, which is called advance parole, by doing that, you abandon your case, which means it is over. It's essentially like it's been denied, and you have to start all the way over from the beginning again, which means paying filing fees again to USCIS, as well as any attorney fees if you are using an attorney to help you in this process. So this means that if you have entered on a tourist visa, you cannot continue using that visa to travel abroad once you have your adjustment of status application pending. All right, so this is generally the process to applying for your adjustment of status. Something else to keep in mind is that over the last year or so, immigration has been waiving a lot of marriage-based green card interviews. So that means that they are making the decision to approve or deny a green card case based on marriage to a US citizen solely based on the documentary evidence that they have that is filed with the case. So this includes evidence of your good faith marriage, things like photos of you two together, communications between the two of you. It could be text message conversations that you've had, proof of having a joint residence, proof of having bills in both of your names. It could look like your spouse having added you to a retirement plan as the beneficiary. There's all sorts of different types of evidence that can count as bona fide evidence to show that the marriage is legitimate and bona fide. Also, you need to provide proof of your lawful entry to the United States. So that can look like a copy of the visa that you used to enter. There's a way to obtain your entry and exit record online through CBP's website. It could look like a stamp in your passport. Whatever the case may be, you do need to provide that proof of your lawful entry along with your adjustment of status packet. Now, with respect to the affidavit of support, your US citizen spouse, who is the petitioner, needs to satisfy certain income requirements in order to be able to file the case for you, to sponsor you. So this income needs to be 125% of the federal poverty guideline for the given year. So right now for 2024, that number is determined based on household size. So, for example, if neither you or your spouse have children, your spouse doesn't have any other dependents on their tax returns, the household size would be two. It would be you and your spouse. So, your spouse would need to earn enough income for a household of two people that is at or above 125% of the federal poverty guideline. This information is available on USCIS's website. Additionally, they need to provide their taxes for the last 3 years. So they need to have filed tax returns for the most 3 recent years. They do need to actually include a copy with the filing of the most recent year's tax return. So this is how immigration sees that they have earned enough money to meet this requirement. Additionally, if they are currently employed, they need to provide proof of that. So that looks like a letter from their employer that says what their position is, if they're working full-time or part-time, how much they're paid, and how long they've been working there. You want to have a letter like that along with pay stubs for approximately the last 2 to 3 months is typically what my office will provide to show immigration, not only based on their tax returns, have they earned enough, but they are actively employed and earning income that also meets the income requirement. Now, if for some reason your spouse is not currently working, they can use their assets. So things like, things they own that they could sell for cash. So, or if they own a home, they can show, what that looks like financially from the mortgage statement as far as what has been paid and what is owed. They can use a car, for example, that they own, like how much would that car be if they had to sell it. They can use like retirement accounts, investment accounts. They can show bank accounts to show USCIS how much money they actually have. So that's a way to continue with the affidavit of support, even if they are not actively employed. Now, if for some reason your US citizen spouse cannot satisfy the income requirement, either through employment or assets, then you, as the immigrant, are allowed to have up to 2 joint sponsors to step in and show immigration that they independently meet the income requirements through their tax returns and evidence of assets or employment. A joint sponsor does not need to be related to you or your spouse. It can be anybody who is a US citizen or a lawful permanent resident who agrees to sign the necessary paperwork and provide their financial information in order for your case to proceed. All right, so I hope this video has been helpful for you. If you have any questions about the adjustment of status process, please feel free to contact me. I can be reached at 760-812-3778. And if you liked this video, please go ahead and subscribe to my channel. Thank you.